Welcome to Looking at Legal Stuff. Today we have 6 hearings, including a new update with the same felon mother who owes her 2 different baby daddies over $23,000 in child support arrears. The judge demands an explanation after she recently sold her home and profited over $37,000, but chose not to pay a dime of that money towards her $23K in arrears. In today's new update, Mom is back in jail. What new charges is she facing this time? Let's find out.
All right, good morning, everyone. Welcome to the family court. This is Judge Husslink. First case this morning is Chelsey Brink versus Devin Hildebrandt. That's file 11-14050-DS. We have Ms. Brink with us. I see Mr. Hildebrandt is with us.
Yes, sir.
All right. We are here today on 2 matters. One is a show cause continued from last month to see whether or not you've submitted a proper amount of job applications to the friend of the court for this week. And then the second one is a supplemental petition for show cause filed by the friend of the court, which alleges that you sold your house in March of this year. They've provided documentation of that from the county records. Indicates that the house was sold for $37,000 and that the only payments since that date total $98.74. So they're asking for a show cause as to why you shouldn't be held in contempt for failure to make a diligent effort to pay a more significant portion of the amount owed after the sale of the house. So as to the proofs for job applications, Ms. Krause, has she submitted the 10 that are required this week?
She actually contacted our office and reported 2 employers. One has been verified and one was sent by electronic verification indicating she was not employed there. She had been previously, so I'm not sure if maybe she just hadn't started yet on that, but right. I do have confirmation that she is currently working for sure at one. No income withholding is set up yet because there's more information that's required from that employer to do so.
All right. Ms. Brink, where are you working at now?
I got a job at Southwoods Pub and Grill, and I'm waitressing. I've been there almost Monday makes a week. And I'm sorry, this coming Monday makes 2 weeks. A week. And then excellent. I was hired at Meyer. But they're waiting on my background check. It's taking Otsego County a long time to get back to Meyer. But I was hired there on 6/30, I believe. And as soon as their background check comes back, then I should be good to go.
That's really good news. They hired
me 5 years ago when I first got out of prison, so I don't see why it should be a problem for my background check to be okayed.
Okay. Well, that all sounds good. Ms.
Your Honor,
Krause?
I'm going to work at Southwoods for my own money, and then I'm going to work at Meyer to pay my child support, just like 3 days a week probably, because I don't want to overdo myself. And I'm going to AA meetings. My home meeting is at 11:45 every day, so I'm going to have to switch meetings. And then I have I guess that's really it. Just the AA meetings going on.
Okay. All right. Mr. Brown wanted to say something. Mr. Brown?
I just wanted to follow up on what Ms. Krause said. I know that they don't have an income withholding order yet, but Chelsey did indicate to me that her employer has received that. It just has not been processed.
Yeah, right. When I talked to him yesterday, he said that he had to have his boss fill it out. So as soon as his boss gets in, his boss is really busy. It's the owner of the restaurant, and he's very hands-on, so he's a very busy man. And as soon as he gets a chance, he will fill it out.
All right. Ms. Krause, is there anything else that Ms. Brink needs to do for the normal show cause proceeding?
Just maybe possibly just making payments until that is, because even if that paperwork is processed, it can take 6 to 8 weeks before money would start to be withheld.
All right.
I just want to say that the first $100 I made, I bought Christmas gifts for my kids, and because they didn't get a Christmas from me last year. So, and then I have $250 in the bank. I have to pay my car insurance because there's a delay on that. I was late on the payment, so I have to pay my car insurance first, my cell phone bill, and then everything after that is going to child support.
All right. Ms. Kraus, what is her
Well,
monthly
not
payment
everything.
supposed to
I
be?
need money to live on, but planned on paying at least $100.
With the case with Hildebrandt, correct?
Correct.
The obligation is $197. That's just for current support. Arrears are $10,801.42.
All right.
And I'd like to see that get corrected because all of that came accumulated while I was incarcerated. And according to Judge Kevin Hesslink on Brian Morgan's case, he said that if you're incarcerated for more than 6 months, child support doesn't accrue or accumulate. And mine accumulated while I was incarcerated. So I'd like to see that get straightened out.
All right, Ms. Brink.
I don't know what I have to do.
Yeah, I'm going to tell you what you have to do right now. You need to file a motion.
Hang on, let me get a piece of paper.
Okay.
Go ahead.
You need to file a motion that says the dates upon which you were incarcerated so that the friend of the court can review to see if there was any increase in the amount while you were incarcerated. And then you need to show whatever documentation you have to prove that you were incarcerated during those time periods.
Well, I don't have any. I got rid of all my, after 1 year, they told me on parole that I had to keep my paperwork for a year, and then after that, I didn't have to keep it. So I got rid of all that paperwork, but I might be able to call the prison and see if they can send me something. I'm not sure.
Your Honor.
All right. Yes, Mr. Brown.
I handled a lot of those cases. I can get that information.
That would be outstanding. Thank you for that assistance. So Ms. Brink, if you can
Thank you,
contact
Mr.
Mr. Brown, he may be able to assist you with that, but you need to file a motion that says when you were incarcerated and proof of those incarceration dates. And then that information can be given to Ms. Kraus and she can do an investigation as to what, if any, amounts were increased during that incarceration period. And then that can be set for a hearing in front of me and we'll make a decision on it.
Okay, thank you so much.
I'm sorry, I didn't hear what you said.
I said, okay, thank you so much.
All right, yep. Ms.
I'll
Kraus,
do that.
is there an ordered on arrears amount in the Hildebrandt case?
There is not.
All right, I'd like to have a recommendation from the friend of the court in writing as to that amount, and we'll have it set for hearing at next month's court date. So that Ms. Brink has an adequate opportunity to review it and see whether she agrees with it or not. And if she wants to disagree, then she'll have a court hearing for that time period. All right, Ms. Brink, the current monthly amount that you owe now that you're working is $197 each month. So we're going to adjourn the show cause to see that you are making that payment. You no longer, because you're employed, you no longer have to do the 10 applications per week. So just keep working, but you need to make your payments now of $197 each and every month. So I'm going to adjourn.
Yeah, I'll put good faith effort into it.
Okay. I'm going to adjourn the first show cause then because you're working. So I'm glad to hear that. And we'll monitor whether or not you're making your payments of $197 each month for the next few months. And if you are, then we'll get rid of the show cause on that. So next, I'm going to turn my attention to this supplemental petition filed by the friend of the court regarding the sale of your home. It's my understanding that the home was sold in March for a price of $37,000, and the friend of the court has not received any significant funds since that time towards your arrearages. Was the home sold in March?
Yes, sir.
And were there any amounts that you received? How much did you receive for the home?
I received one payment of $30,000 and one payment of $7,000.
All right. And why is it that you have not made any additional payments then towards your child support arrears?
Well, can I tell you the whole story? Do you have time?
Well, you can do it in the next 3 or 4 minutes. Yes.
Okay, yeah. So I was living at, so before I sold the house, I was incarcerated. I got, because of the assault on Sean Conradi, who was a heroin addict living in my house. I gave him a second chance. He was living in his truck, starving to death, he told me. So he ended up assaulting me. I called the police several times to try to have him removed from my house. They put me in jail because they were scared I was going to get seriously hurt. I did 38 days, and while I was there, I went to sober living. When I got out of sober living is when I decided to sell my house. While I was in sober living, I got engaged to Brian Morgan, and he moved me down to Davison, Michigan. Well, he assaulted me very, very, very badly, went to jail. And the landlord wouldn't accept like NEMSCA help or any kind of help from me to pay the rent, and he locked me out. Well, I slept, and that happened right after I sold my house. So I bought a camper, and I was living in my camper. I spent $7,000 on, or I'm sorry, $8,500 on that. And then had no vehicle, so I spent $6,500 on my truck. So that was, and I got a really good deal on the truck. I didn't get screwed or anything like that, pardon my language. And so I was living in my camper. Well, I decided that I lost my job at Italia Gardens. So I decided to come back north, and my camper got wrecked. And so I went under the, I don't know what it's called, but I think it's like an awning thing at Travelodge, and it ripped the AC unit off and put a big hole in the roof. And then, so I couldn't sleep in that anymore. You know, I couldn't live in it anymore because of weather. Well, it got towed from McDonald's because when I went through McDonald's drive-through, something caught on the side and ripped the siding off of it. And then, so I spent the rest of the money on hotel rooms to live in. I did sleep in my truck some of that time. I was trying to save money, but by the time I got back up here, most of the money was gone. So what I could afford, I paid out of that money. But most of the money was gone. I had to buy a vehicle. I had no vehicle, and I had to figure out something where to sleep, you know.
The friendly court says that you paid a total of $98.74.
That's not accurate. I paid $200.
Since
Two
March,
$100 bills went there, and I got receipts for both.
they were split between the two cases.
I understand that, but I did pay $200.
All right, so almost 100 of it was credited to this case, and the other amount went to the other case.
Okay,
So
good.
200. Okay, so you got $37,000. You spent $15,000 in total on a camper and a truck. So that means you spent $12,000 on yourself without making any payments for your kids.
I made 2 payments.
$200. So you spent $11,800 on yourself instead of paying it towards your kids.
Well, I did the best I could, sir. I'm sorry that makes you upset.
That's not the best you can. That's being selfish. It's spending money on yourself instead of sending it to your kids.
Well, I haven't spent money on myself in 5 years.
Your Honor, that'd be 22,000 rather than 12,000.
You're absolutely right. Thank you very much for the math correction. I appreciate that.
Well, either way, I'm working now, so payments will come.
Yeah. Here's what's going to happen with those payments, Ms. Brink. They're going to go up substantially. I know that the money's gone now, but I'm going to take that into account when I set the ordered on arrears amount.
You have
You
to base it off
wasted,
what I'm making. You can't just increase it because you want to and you're not happy about my case.
and I will, but I have
You have to
discretion
follow
as
the
to
law.
where it's going to be
that
placed.
formulation.
Ms. Brink, I'm not going to have this argument with you today. I'm simply telling you what I'm going to do. You can object to it next month, Ms. Brink. You can object to it next month when we have the hearing on it, but I'm telling you what I'm disposed to do so that you can prepare yourself for it. I am disposed to, in my discretion. Ms. Brink, I'm talking, you'll wait. I'm disposed in my discretion to raise the amount that you're going to be paying on the arrears amount because you have wasted $22,000 on yourself instead of paying child support. You could have paid off the entire amount of child support that you owe in this case and probably in the other case. All right. We'll have you back in a month. Ms. Kraus has taken notes. She has noted that I will use my discretion to increase the amount of ordered on arrears amount next month to the most amount that we possibly can under the recommendations. So that's all for today. Thank you very much.
Is there a Mason case?
There is, and it'll be called in just a minute, but the next case is not that case.
Okay, I do have to work at 11, so just so you know.
Thank you very much. I'll get to you as quickly as I can.
Thank you, sir.
All right. Similar to the last case, we're here on two matters. One is a normal show cause to determine whether or not you're meeting your monthly obligations. And then we have the supplemental petition to show cause regarding the house sale as well. I understand from the last case that we had that you are now employed and your employer is in the process of doing a withholding order and also that you have sold your house and the funds have been spent. So I'm going to enter the same order in this case that I did in the last case, unless there's some different information that you want to tell me about for this particular case.
I don't think so. I think everything I said is true, and I think I've said everything that I need to say, except for that I do have motions filed for parenting time, and I'd like to get my children over to Petoskey, where I'm living at the Mary Margaret House, to the Children's Advocacy Center. I'm working with APS as well. I have an open APS case for myself and my parents.
All right. Well, the parenting time, Ms. Brink, parenting time goes to Mr. Legal as the referee first. So you'll have to deal with him.
Actually, Dawn Ellison.
Your Honor.
Dawn Ellison.
That has been changed to me, hasn't it? All right. I remember that. All right. I don't see any motions that you filed in the court file for that, though. Have you filed those motions yet?
Yes. It's scheduled July 25th at 10 a.m.
Your Honor.
Yes.
In regards to that, there was a motion that was filed, but there are case notes from the county clerk that was sent back to her with some instructions to complete the fee waiver or send payment. So it would have to be set for a later date.
All right. All I can say, Ms. Brink,
I did do that, and I already mailed it in.
Well, it hasn't reached the court file yet. So once it reaches here, I'll have that hearing.
I haven't seen my kids in 2 years.
Okay, Ms. Brink, once it gets here, we'll have the hearing when it's set. It's just not set for today.
Right. Okay.
I'm not denying you an opportunity to have a hearing. I'm simply saying I don't see it in the court file at the moment, which means it simply hasn't gotten here yet. I'm sure that it's on its way, and once it gets here, we'll have a hearing on the date set for that hearing. But I can't do it today because it's not set for today.
Right.
All right. So on the friend of the court matter, we will do the same thing in this file that we did in the other file. Because she's now employed, she can start making payments. Ms. Kraus, what are the monthly payments that she needs to make in this file?
This specific case would be $252. There was an ordered on arrears order back from 2018 requesting $50 towards overdue support. Her arrears on this case
Which I was incarcerated.
All right, Ms. Brink, you're going to have a chance to make that motion in this case too. We're going to get to that, but you need to let people talk until they're done, and then you can jump in. You can't just talk over people. All right, Ms. Kraus, go ahead.
The arrears on this case is $13,107.09.
All right, Ms. Kraus, I'd like to have you do an ordered on arrears recommendation in this file, just like you did in the other one. I realize that there's $50 a month being paid, but back when that was set, I believe that there was probably a much less, a much reduced arrears amount. So I'd like to have a current recommendation, and we'll schedule that for hearing at the next month's court hearing. And then in the meantime, Ms. Brink, you need to be making payments of $252 a month on this file, and we'll review that next month to make sure that you're able, how well you did on that. And then you can also get with Mr. Brown to get the documentation that you need to make any motions regarding the same thing that you did in the last file about the incarceration time if you believe that the arrears amount is not accurate and grew during the time that you were incarcerated.
It did, and I will. The only thing I was going to say is that, yes, I was incarcerated during from 2017 to 2020, I was incarcerated. So all of that is inaccurate, and I will be filing a motion for that. And I was going to say something else and I can't remember, so I don't want to waste your time. Oh, Mr. Mason has been letting me talk to John, my son, on the phone. So I will say that that is progress in a positive direction. But the only complaint I have is that he is talking very poorly about me, my mother, and my father, probably my sisters and brother. And he's talking very badly about my family in front of my son, and that's causing my son's autism to be worse.
All right, Ms. Brink,
So I'm concerned.
all of those things are parenting time issue things. So I can't consider that today. So when we have the hearing on the parenting time motion, you can bring all of that up to my attention then, and I'll consider it at that time. All right, ma'am?
Yes, sir. And I do want to tell you too that I'm working with NEMSCA and working on getting a place, and I should be in my place like within the next month. But the only thing I was going to say is, am I going to get a whole month between court hearings? Because it's only been 2 weeks since I've been in court. And I'd like to see myself get a whole month in between court hearings so that I have a chance to pay on my child support before I get lectured again.
We try to give you as close to a month as we possibly can. There are some days, some months where it's not possible due to scheduling for other reasons. But we will give you as much notice or much lead time as we possibly can. So this will be scheduled next month at the normal time. I don't know whether that's going to be exactly a month from now or not, but it'll be as close to that as we can possibly get. All right. Is there anything else, Ms. Brink?
I need to update my address with the court as well.
All right. You need to do that in writing to the front of the court, please.
I'm sorry?
Do you want to give? You want to give it to us now, and then you also need to send us a note so that we have the file.
Yes.
Go ahead.
And that's temporary, so I'll have to update my address again once I get it into my apartment in Vanderbilt.
All right. If you would send that to the friend of the court in the mail as well, so that they have that for their file, so that they make sure that they keep that accurate as much as possible, I'd appreciate that. All right. That's all for today, then. Thank you very much, ma'am. Good luck to you next month.
Your Honor.
Thank you.
Would you be able to request that we update the address? Because then we can do that in our system if you order it.
Yes, please. Chelsey Brink.
House is actually here. I don't see her name.
All right. Well,
Your Honor.
Yes. Good morning.
I have tried to contact Chelsey. It appears her phone may have been disconnected, so I'm uncertain of what's going on.
All right. Well, we'll just call the cases and see where we go from there. So, but thank you for the information. All right. The first matter on the court's docket this morning. Oh, by the way, welcome. Good to see all of you. Thank you for being here today. The first matter on the court's docket is Devin Hildebrandt and Chelsey Brink. That's file 11-14050-DS. This is scheduled for a friend of the court petition and hearing regarding ordered on arrears amount and also a show cause amount. I do see Mr. Hildebrandt is with us. Mr. Brown just informed me that he's tried to contact Ms. Brink and was unable to as her phone appears to have been disconnected. Ms. Kraus, have you had any contact from Ms. Brink?
I have not, but she did report a new employer on August 15th.
Are we getting income withholding from her?
We are not receiving income withholdings. She did make a payment that dispersed to 2 of her cases on July 22nd. $43.37 was applied to this specific case based on the disbursement policy.
All right. Mr. Hildebrandt, have you had any contact with Ms. Brink recently?
No, sir. Besides, my daughter had a little bit of contact with her, but that was probably the end of it.
All right. Did you receive the small payment that's been made recently?
Yeah.
All right. What I intended to do today was to find out if she'd made a payment, and if she did, to continue the case till next month to make sure that she continues to make payments. But I also wanted to set an ordered on arrears amount because she owes you quite a bit of money in back child support. And she's not got a specific amount that she's supposed to be paying on that. Ms. Kraus, could you, I know I read your petition. You're asking for $197. I'm sorry, $99 a month to go towards arrears. Is that correct?
It is, and I just wanted to mention in regards to line 3 that it indicates the court would use discretion when determining that amount as the plaintiff's sale of their home and payment history would be considered.
Yeah, I do recall that. It's my memory that she received about $37,000. Is that yours, Ms. Kraus?
I do believe so, yes.
All right, so she got about $37,000 according to her testimony last month when we had a hearing on this. And it's my memory also that she spent all of that on purchasing vehicles and staying in hotels as opposed to giving any of that to child support. Mr. Hildebrandt, did you receive any of those funds from her sale of her house in child support amounts?
No.
All right. Under those circumstances, I believe that an additional amount is appropriate over that. At $99 a month, she owes, Ms. Kraus, is the dollar amount of $10,800 or $801.42. Is that still accurate relatively?
That is accurate as of July 11th.
All right, so it might be a month's worth more than that, but so that's going to take, by my math, it's going to take 9 years to pay off at $99 a month. So I'm going to up it to $150 a month because she had those dollars available to her. She may have spent them now, but it's clear to me that she didn't spend them on child support. So we're going to set the order on arrears amount at $150. Still going to take her approximately 6 years to pay that off at that rate, but at least it's something that Mr. Hildebrandt can get while the child is still in the house with him, as opposed to wait until the child is too old to do anything with it. So we'll set it at that amount. She's failed to appear, but she had proper notice of today's hearing. So that amount will be set on the ordered on arrears amount, and then we will adjourn out the show cause for another month to make sure she pays. If she doesn't pay next month, please let me know. We'll schedule this for next month, and if she doesn't pay, we'll do a show cause on that, or actually I'll consider contempt at that point. Any other questions that you have, Ms. Kraus?
I do not, thank you.
Mr. Hildebrandt, is there anything else that we can do for you, sir?
No, sir.
All right, appreciate you being here. Have a good day.
Thank you, you too.
All right, while we're on the matter of Chelsey Brink, let me call up the other case that she has as well. This is the matter of Chelsey Brink and William Mason, file 13-15199-DC, set for a order to show cause on monitoring her payments, as well as an ordered on arrears amount. Do not see Mr. Mason present with us. And Ms. Brink, we just had a case on in which she failed to appear. Her attorney did not have any contact with her, tried to call and the number was disconnected. The other respondent parent had no contact with Ms. Brink as well. The friend of the court had no contact with Ms. Brink. Ms. Spillane, have you had any contact with Ms. Brink on this matter?
No, sir.
All right, has she made any payments on this file in the last month?
We received $50.63 in July, but nothing yet for August. But as the previous caseworker reported, she just did indicate she has new employment, so the income withholding order hasn't taken effect just yet.
All right, it has been sent out, however?
I believe so. I'll double check real quick.
All right. All right, given the fact that she has made a payment within the last month or so, I'm simply going to adjourn the show cause to see if she makes her payment for this coming month. If she does, I won't hold her in contempt. If she doesn't, I will. As to the ordered on arrears amount, the request from the friend of the court is for $101 of overdue arrears, which is 1/2 of the current monthly amount. I'm going to change that to $150 a month as I did in the other case, because at the last court hearing that we had, Ms. Brink indicated she had received $37,000 earlier this year from the sale of her home and made absolutely zero payments and $0 towards her ordered on towards her arrearages, which in the other file were $10,000, which in this file is in excess of $13,000. For that reason, I'm going to up the payment to $150 because that $101 is going to take in excess of 133 months, which is almost close to 12 years, which is way too long to repay. So even at 150, it's still going to take her 8 or 9 years, which is quite a lengthy period of time to repay a debt. But at least it gives us a chance to have the child to still be in the home when the arrears amounts are received. So we'll set the arrears amount at $150 a month, and then we'll adjourn the show cause to next month to see if she's made her payments. Anything else we can do today in this case, Ms. Spillane?
No, sir.
All right, thank you very much. That's all for that case. The offense of police officer assault, resist, or obstruct, in that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Daniel Gertz, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing your duties. That is a felony offense. It has a maximum penalty of 2 years and or a $2,000 fine. Do you understand the name of that offense, ma'am?
I'm not really sure what you're saying, but kind of. I have resisting arrest?
Yes, that's count
Right.
one. As a maximum penalty of 2 years and $2,000. Do you understand that?
Yeah.
Count two is the same kind of charge, resisting arrest. The name of it's called police officer assaulting, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jacob Depew, a police officer of the Gaylord City Police Department who you knew or had reason to know was performing his duties. That also is a felony offense with a 2-year and or $2,000 maximum penalty. Do you understand the name of this charge in count two is also police officer resisting? And do you also understand that that has a 2-year, $2,000 maximum penalty? All right. In addition to that penalty, there's also a habitual offender notice being sent called fourth offense notice, which enhances the penalty. It says that you did on or about October the 13th of 2020 were convicted of the offense of resisting and obstructing police in the 46th Circuit Court of Otsego County. On or about February the 5th of 2019, you were convicted of resisting and obstructing police in the 46th Circuit Court for Otsego County. And on or about February 5th of 2019, you were convicted of the offense of attempted arson preparation to burn a building, also in the 46th Circuit Court. And because of that, the underlying two offenses have a maximum penalty of, Ms. Brucker, this says life, but I don't know that is it third offense that doubles it, or is it fourth offense that mandates the life sentence? Excuse me, the 25-year sentence.
I'm sorry. I think it should be 15 years, but let me double check that. I might have selected the wrong prompt when I did that. I'm sorry. If I could just have 1 second.
Yep, go ahead. Ms. Brink, she's going to check to see if the information that I have on my paper here is accurate.
All right.
It would be 15 years, Judge, and I'll get that corrected.
All right, thank you. So, Ms. Brink, with the habitual offender notice, the maximum penalty is now 15 years in prison. Do you understand that?
Yeah.
Count 3 alleges that you did commit the offense of retail fraud in the second degree. That is, that in a store or its immediate vicinity, that is Walmart, when it was open to the public, you did steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000. That's a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000, up to 3 times the value of the property that was stolen. You understand the name of the offense to be retail fraud, that is shoplifting?
Yeah.
You understand the maximum penalty is up to 1 year in jail and or a $2,000 fine?
Okay.
All right. Right now you have certain rights. I want to tell you what those are. You have the right to plead guilty, not guilty, or no contest, or excuse me, stand mute. You have the right to have a trial by a judge or by a jury, and you have the right to have an attorney. As to your trial rights, you have the right to see, hear, and question all the witnesses. You have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You have the right to testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal if you wanted to any error that occurred. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
Yeah.
You have any questions about any of those rights?
No.
All right. Mr. Brown, have you talked to Ms. Brink about court-appointed counsel?
I was not really able to get that far, Your Honor, but I am going to say that she is. I currently represent her on a few other cases.
All right. Ms. Brink, I'm going to appoint an attorney for you. In the past, we've dealt with each other, and you've been eligible for court-appointed counsel in the past. So I'm going to do that now. Mr. Gilo is going to assign the specific attorney. It may be Mr. Brown. It may be somebody else. But right now, I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with your attorney. Because you're charged with felonies, I'm also going to set some court hearings on a quick basis so that those protect your rights as well. The first one is called a probable cause conference. That's a chance for your lawyer and the prosecutor to discuss the case quickly to try to resolve it. That'll happen within the next 7 days. We'll also set a preliminary examination date within the next 21 days. That's a chance, that's an opportunity for the prosecutor to prove in court a small amount of evidence called probable cause that you committed the crimes that you've been charged with. Do you have any questions as to the hearing dates that we just talked about?
Oh, I didn't really hear you though.
Do you want me to explain what a probable cause conference and a preliminary examination date is?
Oh, no. I get it. I thought you were setting
Okay.
dates, like giving me dates.
Nope, not yet. All right, what I'm going to do next, Ms. Brink, is I'm going to ask the lawyers about bond, and then I'm going to give you a chance to tell me what you want me to hear about bond as well. So, Ms. Bruker, could you, any thoughts on bond?
Miss Brink is currently on bond for a trespass charge that we're set
No, I'm
for.
not. There was no bond set.
Okay.
Ms. Brink, she gets to talk, and then you'll have a chance to talk afterwards. So I'll listen to you what you want to say, but you got to let her talk without interrupting her, please.
And she's set for an upcoming trial in that case. She was recently convicted of assault and battery back in February. And she does have a history of felonies and misdemeanors on her record that are assaultive as well. I would ask for the standard terms and conditions of bond, including that she not re-enter the Walmart store. I would ask for the court to order that she report to community corrections. I'd ask for the court to order that she follow through with any of her community mental health appointments and treatments. It appears that this crime, as well as her trespass charge, are probably related to some of her mental health issues. So I wrote on the bond sheet a $10,000, 10% bond. I'll leave that to the court's discretion. When Ms. Brink is out in public, she violates the law. She fights with police. We need to make sure that she's safe and the public are safe. But I also recognize that she does need her mental health treatment.
Mr. Brown, your thoughts?
Your Honor, as the court stated, is familiar with Ms. Brink. She does suffer from some mental health issues that she's seeing CMH for. I would ask the court to take that into consideration when setting a bond if she has appointments coming up, but definitely don't want her to miss that. If she's taking any kind of medications, I want to make sure that she is getting the medications that she needs. Other than that, Your Honor, I would leave this up to the court's discretion.
All right, Ms. Brink, this is your chance to tell me what it is that you want me to know about your bond. I would simply caution you, if you don't make any statements about the underlying facts of this case, because we're recording this and it could be used against you later. Is there anything else that you want me to know about bond?
Well, I have no money because I went to prison once already and it destroyed my life and I have no way of working, so I have no money. So that should be taken into consideration. I'm pregnant, so I'm going to need OBGYN care. And when I left the hospital just recently, I told them, please make my appointment for the next day when I get discharged, because I cannot wait that long without seeing someone. I go crazy in the public because I have been to prison and I don't understand people anymore. And they didn't do that. So I went nuts because I found out I was pregnant. So all of that needs to be taken into consideration. $10,000 isn't too bad, but I'm not going to be able to make bond. So it doesn't matter. You're going to keep me in jail and probably send me to prison for this anyway.
Have you been to see a doctor yet about your pregnancy?
No, it's too early to even get a positive pregnancy test.
Are you currently working with anybody from community mental health on your treatment?
Yes, I am. Dr. Gurman is my doctor, and I'm supposed to be getting hooked up with ACT as well. They were going to help me and like get a plate because I'm homeless. And because my parents have dementia, they don't understand that I'm homeless. They won't take me into their house. They keep calling the police on me because they don't recognize me anymore because I went to prison.
All right. So do you think it would be a good idea for you to start working with Dr. Gurman again?
Well, I have a complaint with CMH filed against him for not being fair and violating my rights. So I prefer a different doctor. I've mentioned that to the court once. That hasn't been respected at all. But I need to work with ACT and CMH because I have depression, anxiety, and I don't know.
All right. Are you taking
Depression
any
and
medic?
anxiety.
All right. Thank you. Are you taking any medications right now?
No, I'm not, because I'm pregnant and I want to make sure that it's not going to negatively affect this pregnancy. Even though you're going to take this child away from me, I'm not interested in hurting this child.
Good. I'm glad to hear that. All right.
Yes. It's probably best for me to stay in jail for as long as possible because I have nowhere to go. So when I get out, I'm going to go back to violating the law so I can come back to jail.
Well,
No, that's the fact, Larry. I went to prison.
So,
I cannot
you-
work. Nowhere will hire me. I have no money. I'm stealing food like an idiot.
okay, I don't want you to go into that, please.
Well, I'm just saying. He's asking questions. I'm telling him what needs to be considered with my bond. A PR bond would be nice so I can go look for work and take care of a baby, but that's not going to happen. I'm realistic.
Thank you, Ms. Brink. That's all the information I need right now.
Are you going to set my bond?
I'm thinking about that right now. So yes, ma'am, I am.
Oh,
Just give me a
okay.
minute.
Sorry,
Just
you
give me
didn't
a
say
minute.
anything, so.
No, that's all right. Yeah, I understand.
I'm half nuts too because I haven't seen her talk to my children that already exist in a very long time. So I can't help it. You know, I really can't. I don't even understand that I'm breaking the law. My parents are nuts. I'm getting no support out here.
Well, we're going to try to get somebody to come into the jail and help you with that. All right, we are going to set bond at $10,000, 10%, cash surety or 10%. The reason for that is her past history of violent behaviors, assault, and resisting and obstructing. There does need to be some amount of bond that protects the public. However, because she has a mental illness, it also needs to have some treatment part of that as well. So the requirements, Ms. Brink, are that you appear for any scheduled court dates, that you abide by the judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while released, that you immediately notify the court in writing of any change of address or telephone number. You may not use any alcohol, marijuana, or illegal controlled substances while out on bond. You must participate in a substance abuse testing or monitoring program through community corrections. And you must comply with all community mental health treatment programs. And that includes doctor's appointments and medication as prescribed. You also may not enter the Walmart in Gaylord, and you must contact Community Corrections upon your release. You have any questions about the bond?
No,
Ms.
I'm not
Brink?
going to be able to make bond.
Well, I set it at a point you'd have to post $1,000. If you are able to, then you need to do what CMH tells you to do. Deputy, I asked that you guys call CMH and ask if they can send somebody to the jail to evaluate her and see if they can get her on some prescription medication.
Yes, sir. Can we make an OB? Well, whatever. I'll just tell them and they'll work with me on that way.
All right, that's all for today. Thank you, Deputy.
Okay.
Hold on a second.
Chelsey Brink and Devin Hildebrandt, file 11-14050-DS.
Your Honor, Ms. Brink is currently lodged.
All All right. Ms. Kraus, given that information, what would you like to do today?
Do we have any idea as to where or the length of time, Mr. Brown?
She is in the Otsego County Jail. She was lodged just a few days ago, if not late last week. I believe it's a $10,000 cash surety bond. Her indication is she is not going to be able to post.
I would indicate then, given that, we could potentially, so it doesn't fall off the docket, maybe potentially adjourn it out to December 12th. And if we have information that she's out sooner, we could renotice it.
So ordered. All right. Well, it looks like I forgot one case on Ms. Brink. We have, this is William Mason versus Chelsey Brink, 13-15199-DC. We learned previously from Mr. Brown, when he was present in a previous case with Ms. Brink, that Ms. Brink is still incarcerated. So having said that, it's unlikely she's going to be able to do anything today. Trying to remember what we did in the previous case with Ms. Brink.
I believe it was adjourned to December 12th.
Yeah, let's do that. Keep them both together. That's about all we're going to be able to do today while she's incarcerated. This is the state of Michigan versus Chelsey Brink, file 25-44051-FY. Today is the date and time set for a felony status review. Mr. Brown, I believe this is your case. Is that correct?
That is correct, Judge.
Do we have a resolution of this matter?
I believe we actually do. I was speaking with Mr. Fortier. He has made a plea offer, which is essentially to plead to the retail fraud as charged. There are 2 felony counts of R&O. There is an offer to plead to 2 counts of attempted R&O. I did discuss that with Ms. Brink, and I believe she is going to take that offer.
All right. Mr. Fortier, I believe attempted resisting and obstructing would be a 1 year and or a $1,000 misdemeanor offense. Is that correct?
Correct.
All right. So Ms. Brink, as I understand it, the 2 assault or resisting and obstructing police officer offenses, which are felony offenses, would be reduced down to misdemeanor offenses. And then you would also be asked to plead to the retail fraud misdemeanor. In exchange, the felony offenses for resisting and obstructing police would be dismissed, as well as the habitual offender would be dismissed. Is that your understanding of the agreement as well?
Yes, sir.
And is that what you want to do?
Yes, sir.
Have you had an adequate opportunity to speak with your lawyer about that?
Yes, sir.
All right. If you want to do that, you would be giving up your right to have a trial and all of the rights that you would have at trial. So let me inform you of those so you can make an informed decision. At a trial, you'd have the right to have a lawyer represent you. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own evidence and your own witnesses and get an order from the court requiring them to testify. You could also testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Knowing all of those rights, is it still your intent to enter your plea today?
Yes, sir.
All right, I'm going to have to take some testimony from you. So would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down. Other than this plea agreement that we've talked about today, has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right, let me start with the police officer charges. The new or amended charges would be attempted resisting and obstructing, a 1-year misdemeanor. And they would say that on or about September 21st of 2025 in the city of Gaylord and Otsego County, that you did attempt to assault, batter, wound, resist, or obstruct, or oppose, or endanger Officer Daniel Gertz and Officer Jacob Depew, police officers who you knew were performing their duties. Is that what you did?
Yes, sir.
Can you tell me what you did to those officers that was resisting and obstructing them?
I just didn't turn around when he asked me to, the first time he asked me to, and kind of I ran my mouth to him.
Well, typically, attempted resisting and obstructing has to do something more than just talking. It's got to be some physical activity or some action that you took that either resisted them.
Right, that's what I'm saying. I didn't turn around.
Okay. Did you take some physical action either towards the officers or with the officers?
No.
Mr. Brown, is there any questions that you want to ask at this point?
Yes, Your Honor. Chelsey, do you remember being at the Walmart when the police showed up?
Yeah.
And you were there because I believe Walmart had called because of a potential theft, right?
Right.
And when the police were there, were they asking you to do certain things, giving you commands?
But he just said, after he questioned me about what happened, you know, I have mental health problems, so I get sick sometimes, and I wasn't quite understanding what was going on. But anyways, he said that I was going to be arrested, and Depew asked me to turn around, and I said, I dare you. And so, like an idiot, he came at me and grabbed me by the arm, and I didn't move from where I was standing. You know, I didn't assault him or anything like that. I just didn't help him arrest me. I mean, it's hard for me to agree to something so.
Did you tense up while they were trying to?
I probably will always resist because I don't agree with some of the laws, you know.
Well,
so
Ms. Brink, they gave you a command. You did not immediately comply with that. When they were trying to arrest you, did you kind of resist by tensing your arms up so they could not do that?
Yes. Yeah.
Thank you.
Were
they in full uniform? You knew they were officers, correct?
Yes, I did. Yeah.
Okay, thank you.
All right. Any other factual basis questions that you have, Mr. Fortier?
No, Judge.
All right. As to count 1 and count 2, I do find that she's given me a proper factual basis. She's resisted the lawful arrest and the commands for the arrest by the police officers at Walmart in Otsego County on or about September 21st. Ms. Brink, as to count 3, which is the retail fraud, that reads that on or about September 21st of 2025, that you were in the Walmart store, which was open to the public, and you stole property of the store that was offered for sale at a price over $200, but less than $1,000. What did you do there?
You know, by the time I got to the door, actually, let me back up. I went in to use the bathroom, to be honest with you. Actually, let me back up even further. I drank a beer and I relapsed, and the day before, I spent the whole day.
Chelsey, I think what he's asking you is, did you take anything? I don't necessarily know if he needs the entire story. Did you take anything?
Yes, I did take stuff. It was a baby seat and.
Ms. Brink, hang on a second. I'm going to give you a chance at sentencing to tell me all of the reasons why things happened. At the plea, I just need a small amount of information from you. So let me be specific. Sure. Did you go into the Walmart store when it was open to the public?
Yes, I did.
And that was on September 21st, right?
Yes, I did.
Did you steal property? Did you take without paying for certain property of the store?
Yes, I did, sir.
What were the items that you took without paying for?
A baby seat. I saw a baby seat, a backpack, and I think there was, from what I recall, there was a blanket and something else, nail clippers or something, and a backpack. Did I say that?
All right, and
I think that was it.
And all of that stuff, did it add up to a value of more than $200?
Probably, yeah. Yeah.
All right. Any other factual basis questions that either of the council have?
No, Judge.
No, Your Honor.
All right. And again, I find that Ms. Brink has given me a proper factual basis. She's admitted to stealing property of the store from Walmart that was open while Walmart was open, and the value was more than $200. Are either council aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
No, Your Honor. And the court has complied with court rule.
All right, I will accept then the pleas as to all three of the charges. I do find them to be knowingly, intelligently, and voluntarily done, as she has properly answered my questions about promises, threats, or other inducements. Let me just make some notes. All right, Mr. Fortier, do we need to get some information from Walmart and give them an opportunity to be here for sentencing, or can we proceed today?
We can proceed today.
Mr. Brown, do you wish to proceed today?
Yes, Judge.
All right, Ms. Brink, what I'm going to do is I'm going to ask each of the lawyers what they think we should do for sentencing. And then I'm going to, after you've heard what they say, I'm going to give you a chance to tell me anything that you want me to know as well. So listen carefully. Mr. Fortier, your thoughts on sentencing?
Judge, after having an opportunity to review the video for this one, I think it was pretty clear. There were some outside factors going on with Ms. Brink. Frankly, I think the court's well aware of kind of what's been going on with her history. I think an appropriate sentence would be giving her some jail time with credit for what she's already served, but then putting her on probation. I would leave up to the court. If she is going to be on probation, I would ask that she continue any sort of mental health treatment that she is undergoing or should be undergoing. I think CMH, if they're not already involved, should become involved. And to that extent, whatever treatment recommendations she has, I think she needs to follow through with. There is no restitution as well, as all items were recovered. And I had an opportunity to talk with both police officers that were involved, and they understand that there were additional factors outside of just what most people might think is going on. So they were okay with the attempts.
Mr. Brown, allocution.
Thank you, Your Honor. I would largely echo what Mr. Fortier said. I am not going to rehash her history on the record. The court is very well aware of it. All I'm going to do is ask the court to fashion a sentence which primarily deals with her mental health, which is, I think, what should be the focus. Obviously, there is an element of punishment. She has been sitting for quite a while. But I want her to get the help that she needs. Thank you.
All right. Ms. Brink, this is your opportunity to tell me anything that you want me to know about you and about what you think the sentence should be. So if you have any comments, this is now the time to make them.
Good. Mostly, I just want you to know that I did relapse and drink a beer after being sober for about almost a year now. And so that negatively affected me. I spent an entire day trying to sober up. I had not taken my medication that day. Sometimes I'm usually pretty good about it, but I don't know what happened. I'm homeless and I've been living in my vehicle. It's very lonely being homeless. And you know, I've got mental health problems, and so I don't always 100% understand what's going on, to be honest. So I just want the court to understand those things, and I appreciate Mr. Fortier being so kind with his words about about what you think I should be sentenced to. Larry Brown did a great job, in my opinion, representing me. And I'm embarrassed mostly, and so it's even hard to even verbalize how I feel right now and what I want you to know. And I'm ashamed of myself because I didn't think I would, after prison, I didn't think I would end up in this position again. And so I feel horrible, and I fucked up. Excuse my language, but that's the truth of it. And my parents are ashamed of me and embarrassed of me. And so that's enough punishment for me, to be honest. But I know you have to impose a sentence. And so if you can just give me work camp or probation or something minor, I don't know, because even if they let me out of jail, I don't know where I'm going to stay yet. So just take those things into consideration, I guess, if you can.
All right. Well, Ms. Brink, I want to say thank you for the work that you've done to get yourself back together with your mental health treatment. There's a world of difference between today and some of the previous conversations that we've had. And I want to say you're doing much better today. And I appreciate that. You're a thoughtful person today. And I think that bodes well for if you stay on your medication and stay on your treatment plan, things can go much better for you. But
yes,
that's
sir.
kind of where,
When I was in prison and even slightly before that, I wasn't working with CMH right away, but they messed with my meds a lot, and it got me all kinds of confused because they would change it a lot. While I was in prison, they changed my medications a lot. I had some seizures. I hit my head a couple times. But when I got out of prison, since then, working with CMH, they've changed my medication so much, and so it's very hard to understand what's happened from then until now, without getting outside person's opinions, because or facts even, really, because I know I've been in the hospital a lot. I can tell you that, and been in jail a lot, but I don't they just change it, and so the shot of Abilify works pretty good. And so does the Zoloft and gabapentin. I need to get back on metoprolol for my AFib. I know that, and the gel's working with me on that too, so that's good.
okay.
But
Well, I'm just simply going to say that the doctors are the ones that control all that kind of stuff. They're the ones that, and sometimes they have to experiment and see what works best for you. But I'm going to require you to do that, to work with them. So let me ask you just one other small question before I tell you what the sentence is going to be. How much time have you been in jail now, up to this point?
I believe a month. Monday will make a month.
All right, so at least 25 days?
Yes, sir.
All right.
I believe so anyway. Today's I don't even know the day of the week. Thursday, I think.
Yes, today is Friday.
Today's Friday. Okay.
Friday the 17th. Have you been in jail for all of October and part of September? All right.
Yes, sir.
Okay.
So since the 22nd of September, I've been in jail.
All right. I'm going to put you on probation for 6 months, just so we can make sure that you're doing what you're supposed to be doing with your medications and with your treatment.
Right. Yeah.
There's a cost for that. There's a $75 mandatory crime victim rights fee, a $50 justice assessment. I'm going to reduce I got 3 charges I got to do things on, so bear with me for just a minute. I'm going to reduce the court costs to $100 on each one of them. And I'm going to reduce the fine to $50 on each one of them. And then there's a $180 probation oversight fee on each one of them as well. So let me add up those amounts. It's a total of $770, and you can pay that over the course of probation.
Okay, over the course of 6 months then?
Yep.
Okay, thank you.
I'm going to let you do community service work if you can't find work right away, so that you can work that off at the discretion of the probation office. There are some fines that you have to pay yourself, but you can enroll in some of them. I'm going to require you to go to CMH, Community Mental Health, and follow all recommendations and submit a release to probation so that they can know what you're supposed to be doing with community mental health and what your treatment program is. All right?
Yes, sir.
So take all your medications, go to counseling, whatever they tell you to do, that's what you're going to have to do.
Right.
No consumption of alcohol or non-prescribed drugs. That means if your doctor tells you to take a drug, then you take it, but you can't take street drugs and you can't abuse your prescriptions. You understand what I mean by that?
Yes, sir. Yes, sir.
I don't want you to go to any bars or places where alcohol is served by the glass. So stay out of there. That way, because if you're mixing your medications with alcohol, bad things happen.
Yes, I know. Yes, I know.
All right. I am going to send you, because you're not working right now, I am going to send you to the work camp for 10 days so that you can give back to the community. That'll make you feel a little bit better about yourself too once you get out and you're able to do something. And hopefully that'll give you a little bit of structure so that you know where you're supposed to be and when you're supposed to be there.
Okay.
Mr. Fortier, are you aware whether or not the United Way still deals with people that have housing issues?
I do not know.
Mr. Brown, are you aware of any other agency in the community that deals with housing issues that could help her find some place to land?
Unfortunately, no. I don't know if NEMSCA deals with those things or not.
There used to be an agency called First Call for Help that had a way of doing the phone tree and calling places like that. I'm going to ask probation to contact community mental health and help her deal with the homeless issue, or at least make some referrals, see what is out there.
Because I don't know where I'm going to live, is it okay if I ask when I'm getting out of jail? Like, is that happening today? Because I'm a little bit nervous about that. I have nowhere to go. Should I just try United Way when I get out to see if they'll put me up somewhere or something?
Yeah, I'm gonna ask our probation department if they know of any other community resource that deals with homelessness. I don't know that we have a specific shelter in town anymore. We used to, but I don't think we have one now. But I believe that DHHS may have some funding available for emergency bases.
Okay.
And I'll ask our probation department to call and see if there's anything that they can point you to when you are released. I'm going to give you 25 days in jail credit for 25 days.
Great.
So you don't have to serve. You don't have to serve any additional jail time, but you will have to go to the work camp, and so you're going to need to contact them to get that set up and get started with that once you are released. And I'm going to ask probation to try to see if there's any place that we can put you, or that at least you can go and make an application for a place to stay. I can't guarantee anything, but we'll at least work with you and try to help you that way. Are there any other questions that you have, Ms. Brink?
No, sir. That was all.
Mr. Brown?
No, Your Honor. Thank you.
Mr. Fortier?
No, Judge.
All right. Good luck to you, ma'am. Please, for everybody's sake, stay on your medication and do your counseling like you're supposed to, okay?
Yes, sir, I will.
All right. Good luck
Thank
to
you
you.
so much. Yes, thank you. Thanks, Larry.
4 weeks later.
Are you Chelsey Brink? I have to hear from you, ma'am.
Yeah.
All right, thank you. I'm Judge Hesselink. I'm coming to you from the district court. You're here today because of an arraignment. There's actually two files, a new file and a probation file. Let me call those cases. The first one is the State of Michigan versus Chelsey Brink, file 25-44174-FY-3. That is set for a new arraignment. And we're also here today on the State of Michigan versus Chelsey Brink, file 25-44051-F3. That's a probation violation file. Let me turn to the first new file. With me today to assist in that is Richard Trush, defense counsel, and Mr. Fortier from the prosecutor's office. The new charge against you reads as follows. It says that on or about November the 18th of 2025 in the city of Gaylord, Otsego County, in count 1, you did commit the offense known as police officer assault, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Colton Huff, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is would normally be a felony offense with a 2-year and or $2,000 fine. However, you've also been charged as a habitual offender fourth offense notice, which has the effect of enhancing the sentence. That notice says that you were previously convicted of 3 or more felonies or attempt to commit felonies. In that on or about October the 13th of 2020, you were convicted of the offense of police officer assaulting, resisting, or obstructing in the 46th Circuit Court for Otsego County in the state of Michigan. On February the 5th of 2019, you were convicted of the offense of attempted arson, preparation to burn in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about February the 8th of 2018, you were convicted of the offense of felony kidnapping, custodial interference in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, there is an enhanced penalty, and because the underlying offense has a penalty of less than 5 years, the new penalty would be up to 15 years in prison. Do you understand the name of count 1 to be police officer assaulting, resisting, and obstructing?
Yeah.
Do you understand the maximum penalty under the habitual fourth offense notice for that charge is now up to 15 years in prison? I'm sorry, I have to hear something from you, either yes or no, ma'am. I'm sorry, I was not able to hear you. Thank you for making it a little bit louder. Count 2 reads as follows. It's entitled police officer assaulting, resisting, or obstructing. It says that on that same date and time, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Depew, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. Again, that would normally be a felony offense of 2 years and or $2,000 fine. However, you have also been charged with the habitual offender fourth offense notice that I just read to you on as to count 1. That now applies to count 2 to make that a felony offense with a maximum possible penalty of 15 years in prison. Do you understand the name of count 2?
Yeah.
Do you understand the maximum penalty for count 2?
Yeah.
All right. Count 3 is the name of that offense is Mail and Mail Depository Protection Act, also involving mail theft. It says that on that same date, time, and place that you did take, hold, conceal, or destroy mail addressed to another person, that is Lisa's Tavern, with the intent to deprive that person to whom the mail was addressed of the mail, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 1 year and or a $500 fine. Do you understand the name of count 3?
Yeah,
Do you understand the maximum penalty for count 3?
yeah.
The final count, count 4, reads as follows. It says that on that same date, time, and place that you did commit the offense known as trespass, in that you did remain without lawful authority to remain on the lands or premises of Lisa's Tavern after being notified to depart therefrom by Elizabeth Arndt, who was the agent of the occupant of the lands or premises, contrary to Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 30 days and or a $250 fine. You understand the name of count 4?
What is it?
It's called trespass.
Oh, yeah.
You understand the maximum penalty of 30 days and or up to $250 fine?
Yeah.
All right. You have certain rights, and I want to make sure that you understand those rights so you can decide what to do with them in the future. Your basic rights are you have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or a jury. At that trial, you would also have trial rights, which include the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could remain silent, and if you chose to remain silent, that silence could not be used against you. At trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you have any questions about any of those rights?
No.
Do you believe that you understand those rights?
Yes.
All right. Mr. Trush, as to her right to an attorney, have you had a chance to speak with her about that?
I did, Your Honor. She has been screened and qualifies for counsel. Again, traditionally, I think she's been represented by Mr. Brown. I expect he'll be appointed in this matter as well.
All right. Ms. Brink, until you have a chance to speak, with your attorney, I'm going to enter a not guilty plea on your behalf in order to protect your rights. Because you've been charged with felony offenses, I'm also going to set some quick court dates to also protect your rights. The first date is called a probable cause conference. That'll happen in the next 7 days. That's a chance for your lawyer and the prosecutor to speak to see if they can resolve the case quickly. In addition to that, within the next 21 days, we'll set a preliminary examination date. Now, that's a short hearing in district court in front of me as the judge to determine whether or not the prosecutor can show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It is simply a check to make sure that there's sufficient evidence to proceed with the case. Do you have any questions about those 2 court hearings?
No.
All right. What we're going to do next is address the issue of bond. So I'm going to listen to both of the attorneys, and then I'm also going to give you an opportunity to tell me what it is that you want me to know before we make that decision. Mr. Fortier, as to bond.
Your Honor, I did submit a bond recommendation form. In it, I want to note that she is on probation currently in case 2544051-FY, where she was sentenced to 6 months probation on a retail fraud 2nd degree and 2 counts of attempted resisting and obstructing a police officer. She was sentenced on October 17th, 2025, so just about a little over a month ago. I think based on the fact that she was out on probation for an assaultive offense, she's got assaultive offenses in her criminal history. She does present as a risk to the community at large. The court's obviously well aware of issues that Ms. Brink has. She's continuously picking up trespassing and R&O charges when the police are called. So based on that, I think a bond amount of $10,000 cash or surety would be adequate. I would also ask that, in addition to the standard conditions of bond, that the court order no drugs or alcohol be consumed, along with no marijuana, and that she participate in a substance abuse testing or monitoring program at the discretion of community corrections. Ask that she would report via community corrections and that she participate in a specified treatment program, specifically with community mental health. I know she had indicated prior circumstances that she was involved with them. However, I'm not sure the extent of that involvement right now. I think it needs to continue, or at least be essentially restarted if it's not happening. I would also ask that she have no contact with Lisa's Tavern, that she not re-enter Lisa's Tavern, and that because she is charged with an assaultive crime, on top of the fact that she's got felony criminal history, that she not possess any weapons or firearms. And that's it.
All right. Mr. Trush, your thoughts?
Thank you, Your Honor. In regards to bond on this matter, a few things that I think are important. Given the circumstances, we expect some amount of cash bond is going to be put in place here. I would indicate Ms. Brink has substantial connections to the community. She's essentially lived her entire life in Otsego County. I think the court is familiar with some of her economic circumstances. She reports that she's homeless. I know that she has reported that to the court consistently, I think, in other hearings, which I wasn't a party to, but happened to be present and observe. She reports that she struggled to get a job since being released from prison, with a felony on her record. She reports that it's disqualified her from a lot of jobs. She reports that she's always appeared. And again, I would just indicate to the court, I think that some cash bond is surely going to be put in place here. $10,000 seems high. I would suggest to the court a $5,000 bond is more appropriate. And I would suggest to the court, again, the court I think is aware of some of her other economic issues. And frankly, the fact that she has some other matters, which frankly, if she had available funds, I think would be more appropriately put to those than to a bond here. Thank you.
Ms. Brink, you do have the right to address me as to anything that you think would be important for bond. I would simply caution you that not to make any statements about the underlying facts of the case, because we are recording this and it could be used against you later. But if there's anything that you want me to be aware of, I'd be happy to listen to that now.
I'll stand mute.
All right, thank you. All right, I do note, as the prosecutor indicated, that Ms. Brink has just recently been sentenced on a case that involved, at least in part, resisting and obstructing, or attempted resisting and obstructing police officers on the same offenses that she's now alleged to have committed on this particular case. She was on probation at the time that she was alleged to have committed these charges. That she has ties to the community, but she has indicated to me in not only that previous sentencing, but in the other cases that she's been involved with the court, that she is homeless. I believe that she sold her home that she had here in Otsego County a couple of years ago and used that money basically to stay in hotels for a little less than a year. She has not, to the best of my knowledge, had any long-time employment, if any employment at all, in the last year or so. So while she is well known to the court system, she has very limited things that tie her to this community, other than the fact that she may have people that she knows in the area. So because of her inability to keep herself out of trouble and the fact that she is being violent towards our police officers, I believe that a cash bond of $10,000 cash and surety is appropriate in this case. Conditions of release on that bond include personally appearing for all court dates set by the court, abiding by any judgment of the court, not leaving the state of Michigan without prior permission of the court, not committing any crime while on release, and immediately notifying the court in writing of any change of address or telephone number. She must also not use alcohol, marijuana, or any illegal controlled substances while out on bond. She must participate in a substance abuse testing or monitoring program through community corrections. She must participate in a specified treatment program for any physical or mental condition, including substance abuse, and that was specifically would be community mental health, and follow all recommendations of that assessment. She may not, because of her danger to the others in the community, she may not purchase or possess a firearm or other dangerous weapon while out on bond. She may not have any contact with, direct or indirect, with Lisa's Tavern. That means she may not call it, she may not show up in person, she may not use the internet or social media. No contact means no contact. Finally, she may not enter Lisa's Tavern in Gaylord as well. And then upon her release, she must contact Community Corrections within 24 hours of her release so that they may monitor her while she's on bond. Ms. Brink, do you have any questions about those bond conditions?
No.
Mr. Truce, anything?
No, Your Honor, thank you.
Mr. Fortier, anything else?
No, Your Honor.
All right, Ms. Brink, we also have one additional matter. Before I forget, Deputy, could you make sure that Ms. Brink gets fingerprinted on this new charges as well?
Yes, Your Honor.
Thank you very much. All right, Ms. Brink, we also have a probation violation issue. The allegations made against you on that is that you were charged with a new criminal offense of larceny, resisting, obstructing, and aggravated assault on 11/18 of 2025. That's the charges that I just read to you. Well, I'm not sure if that's exactly the way it should be read, but you've also been charged with police officer resisting and obstructing, and trespassing, and mail theft. The recommendation is that you serve 93 days in jail and that you be discharged from probation with fines and costs preserved. Do you understand the nature of the allegation made against you?
Yeah.
Do you understand the recommendation as to what would happen if you were to admit or be found guilty of that?
Yeah.
All right. I'm going to assume that you wish to have an attorney represent you on that matter as well. Is that correct?
Yeah.
All right. And I will, because I've just heard that you have qualified for court-appointed counsel, I will appoint court-appointed counsel or send that to Mr. Gilo to determine who should be your lawyer in that. I'm going to enter a not guilty plea on your behalf until you have an opportunity to speak with your lawyer about that. And then we're going to set a court date in conjunction with your new felony offense so that they're both heard at the same time. I don't know what that date's going to be yet, but we'll have that done for you. And we'll send the notice to you at the jail or at the address that you give us as to where you want mail sent to. Where would you like to have notices and mail sent to, Ms. Brink?
I'm in jail. What do you mean?
If you get out, obviously, if you're in jail,
I'm not
we'll
going
send
to
it
get
to you
out.
there.
I'm homeless. I have no job and I'm homeless. I'm not getting out.
All right. Does that mean that you don't want to have a mailing address to where you can pick it up from
Right.
somebody else?
Right. I got no mailing address.
All right. So we'll send the notice to you at the jail. Do you have any questions about that?
No.
All right. That's all for today then. Thank you very much. You're free to go.
From Plains to Prison, written by Chelsey Brink. One decision, although seemingly insignificant at the time, can affect a whole life, and in turn has the ability to affect multiple lives. You see, before prison, I was a highly respected member of my community. I became a registered nurse in 2011 and worked and volunteered as such until 2017. I owned a 2,500 square foot 5-bedroom house. I have 2 children who were taken away from me by their fathers, and like I said, one decision has the ability to completely derail a life. I've been incarcerated since 2018. I did 10 months in county jail before coming to Women's Huron Valley Correctional Facility. I came to WHV on October 15th, 2019. I was only supposed to be here for 6 months for a probation violation. 6 months has turned into a hellacious almost 18 months. I completed my required coursework in the first 6 months. It was required that I take healing trauma, Phase 2 substance abuse, and beyond violence classes. I put forth effort in my classes and took it serious, thinking it could only help me and would facilitate a faster release from WHV custody back into the community. How wrong I was. These are weird times, I will admit. With the onset of COVID-19 pandemic, so much has changed. Beginning in March 2020, all prisoners have been required to wear face masks, which are suffocating. The prison has been shut down for a year now. It's only been in the last week that we've received new inmates. The school and all core programming have ceased to exist. On Monday, a couple of classes restarted. Prison is hell. There is no other way to describe this place. The food is nearly inedible. The healthcare and mental health care services are terrible to non-existent. Not to mention, I'm 12 months past my earliest release date. I've been given too many unfair tickets, and I've spent 113 days total on sanction. I've been disrespected on every level. It seems that certain individuals at the prison have forgotten who I am. I guess I can't expect them to remember me when I've forgotten who I am and when I didn't stay true to myself. I've settled in and I'm working hard to make my situation livable, pushing against the wildness while the wildness pushes back with everything it has. I remember when I was in county jail, I kept saying to others that the system is broken. But the thing I had forgotten along the way somewhere is that dying and killing are part of God's plan too. It's part of life. The question, though, is am I dying or killing? Is it possible to do both? And whose lives are affected by dying and killing? And how? There are times I could scream with the frustration of the uselessness of my own brain. But through the last 18 months, the thing I have found time and time again is that the human heart proves the most confounding mystery of all. I've learned to be patient with myself first, and have remembered to only believe half of what I hear and all of what I see. I sometimes think that being loved a little less than others can actually make a person rather than ruin them. Trouble is the only thing that seems to stick with me with any regularity, but I'm learning to think that can shape a person too. I've never known how to handle money. I'm not sure I understand it. The love of money is the root of all kinds of evil. Some have strayed from their faith in their greediness and have pierced themselves through with many sorrows. Just because you break the law doesn't mean you have intentionally crossed the line into evil. Sometimes the line creeps up on you, and before you know it, you're standing on the other side. It is rare that what is expected and what is right are the same set of footprints. There are always exceptions to the rules, and the same applies to the letter of the law. Since being incarcerated, I have remembered that what I don't say is probably more important than what I do say. I don't want anyone's sympathy or to be coddled. I don't want anyone's pity or platitudes. I just want my old life back. And that notion, the utterly gut-wrenching, soul-crushing feeling that your life has been stolen from you, is something that you cannot fathom unless you've been through it yourself. Every terrible thing that you've been through in your life up until that point pales in comparison or seems downright ridiculous. You don't even know where to begin. I know I didn't, but I'm trying to make my way back to who I was, and in the process, I'm learning who I am. But it's a difficult journey. I've had to remind myself time and time again that we are not our past, no matter how traumatic or life-changing it might have been. You don't have to be superhuman to survive the bad times, and you can't always be at your best. But even when things look their worst, you can still feel positive about the future. Being optimistic is simply a choice made possible by being creative and proactive. A happy ending begins with having faith in your own story and looking for ways to create joy for yourself and others. We are all our own journeys, hopes, and dreams clad in mortal wrapping paper. And no matter how lost, lonely, defeated, or damaged we feel, accepting the love of others and loving them in return, to whatever return we can, will help make us feel whole again. I find some solace when listening to music, and also enjoy the escape afforded when reading. When your body craves physical relief, you can only listen to so much music and read so many books. It's been so long since I was a child that I've forgotten that there are building blocks of love, and that at the very bottom is comfort. Choice is a part of what makes us human. Love isn't doing whatever the person you cared for expects of you. It's doing what they don't expect, going above and beyond what you've been asked. Nothing stands out so conspicuously or remains so firmly fixed in the memory as something which you have blundered. I've learned that sometimes it's necessary to reteach a thing its loveliness. There are times I almost think I'm not sure of what I absolutely know. Some lessons WHV and being incarcerated have taught me are to soak up all the wisdom around you. Make time to dream big dreams and find people who believe in them. Learn from the people who know how to roll on the road and be ready to lay down your own asphalt. Know how to seize upon your own moment. Keep your real friends close. Make your mother proud. Honor the place you came from. Do the work, then enjoy the ride. I have to choose between what hurts and what hurts worse. It is a rare soul who would stand against a crowd.